A very warm welcome to Radio Sofia, and today is a very special session to us because often many people ask me what the story behind name Sofia is. So Sofia is the name of a young kid who is born to a Hindu-born mother and a Muslim-born father who got married at a later time, and they thought the word Sophia, meaning wisdom, is a beautiful name to give to a child who is born out of an interfaith marriage. And therefore, I think this session is of extreme importance and to all of us at Radio Sofia especially. And I'm also deeply honored to host one of the well-known human rights activists and a senior advocate at the Supreme Court of India, Ms. Indira Jaising. So Jaising co-founded the Lawyers Collective, a legal NGO that has been working since its inception in 1980 for the rights of the marginalized, particularly women, LGBTQ people, sex workers, and many more economically and socially disadvantaged groups. Jaising has also fought and won a number of landmark legal battles, particularly those dealing with Christian women's right to inherit property, right of the mother as the natural guardian in child custody cases, or having the Supreme Court strike down instant Triple Talaq as unconstitutional. The list of her work in fighting for human rights is quite long and probably could take a session in itself. But to put it in a nutshell, she has been working all throughout to ensure the independence of judiciary. Without any further ado, let me welcome Ms. Indira Jaising. Thank you very much, ma'am, for joining us and readily agreeing to deliver a wonderful talk at Radio Sofia.
Yeah, hi.
Thank you. So now I invite questions from the audience. You can kindly post your questions in the chat box. Ma'am, so before we move on to the audience, before we take audience questions, so firstly, I would like to ask you, as a human rights activist, why do you think freedom of religion is important to individuals and why Indian state should remain secular? You have already mentioned that in the talk that you do not wish others to dictate who you want to marry, which religion you want to marry in, or which religion we should follow. So could you elaborate on that?
Yes. I'm sure that all of us will agree that we do live in a country which has people belonging to multiple religions. The history of this country at its commencement, which was a partition of the country into India and Pakistan, accompanied by a lot of violence at that time, was along communal lines. And this meant that India took a conscious decision, a choice, to have within its boundaries people belonging to many, many different religions without insisting that they owe allegiance to a single religion. So the importance of secularism lies in the fact that we are a multi-religious country which was founded at its commencement as a secular country. Now, why is it important to remain secular? Because we have very, very large religious minorities in this country. And unless we want to move on to a system in which we say, no, every single person living within the boundaries of this country must belong to one religion alone, it is important for us to preserve the secular fabric of this country. Apart from that, as I've already explained, religion is something very, very personal. And as I said, it's linked to your conscience. So therefore, to insist that a person must belong to one religion and not another religion would be against a person's own conscience. And there is no law in the world which can crib and cage a person's conscience. That is a freedom which your mind has, there's a freedom which your conscience has to do as you wish in relation to your own religion. For that matter, you have a right to believe in no religion at all. You can be an atheist, you can be an agnostic. That's also part of your act of conscience. So that's why I think it's very important to preserve the secular fabric of the country.
Ma'am, so actually you also mentioned in the talk that we are born into the religion of our parents and we do not have a choice over that. But legally, do Indian citizens at any stage have a legal choice to renounce the birth religion as well as not adopt any other religion, regardless of marriage?
Indeed, they have. They do have that choice. The only slight ambiguity could be is when does one exercise that right, okay? So for want of a better word, I've said it's at the age of discretion, it's at the age of majority, it's at the age of maturity, okay? So at the very least, one can say that when one attains the age of 18, one is considered a major, and from that time onwards, your decisions are your own. They cannot be dictated to by anybody. So the answer to your question is a direct yes. You do have that choice.
Thank you. So now there is another, actually in your article published in Leaflet in January, you mentioned that individuals and not institutions have the right to freedom of religion. Right. So we have the Article 25 to 28 guarantee every citizen the right to freely profess, practice, and propagate religion. So in this context, what are the limits, or how should we understand the idea of propagation of religion? Can institutions propagate religion or not?
Yes, the relationship. First, you must understand very clearly that who does the right belong to? Does it belong to an institution? Does it belong to you as an individual? And the answer to that is that it belongs to the individual, not to the institution. What the institution does is provide you with a collective forum, a place through which you can channelize the exercise of that right according to certain rituals, according to certain norms, according to certain well-established ways of exercising your right to religion collectively. So I would once again say the answer is very clear. The right belongs to you. But without an institution through which that right can be exercised, your right to practice religion becomes a little incomplete. What institutions do have is the right to hold property, for example. So the ownership of a temple or the ownership of a church or the ownership of an agyari can be vested in an institution. It may be a society, it may be any other legal form. It is an institution. But this institution is basically helping you to exercise your right to freedom of religion.
Ma'am, so just before moving on, talking about particularly anti-conversion laws, so one more question in this regard is that now we have established that religion is a private matter, the belief or the practice of religion is a private matter, whereas also institutions have certain rights over owning property or, practicing the religion. But now in the recent past, we have seen a rise in the number of religious TV channels, for instance, right, in almost every native language or the local language. So now if these religious channels are inciting hatred or increasing polarization through religious indoctrination, banning them or regulating them, would it be considered as a violation of the freedom of religion too?
Okay, so Article 25 itself contains 3 grounds on which the right to religion can be curbed or regulated. It is public order, health, and morality. So the example that you give of inciting hatred could lead to a breach of public order and could be regulated. Apart from that, the ordinary law of the land would apply to institutions, whether they're religious institutions or not. Many cases have gone to court, things like, broadcasting through mics, which are attached to institutions. Do they disrupt public order? The answer has been yes. Can they be regulated? The answer has been yes. There was the Anand Margi case where they claimed the right to take out processions with arms. The court said, no, this is opposed to public order. So the right can be regulated, but on these three grounds: public order, health, and morality.
Right. Ma'am, so now in the talk, you mentioned that state-level acts have existed in at least 8 states since 1960s, much before the UP government moved an ordinance in 2020. So have the state laws ever been challenged? If not, why?
Yes, the first of those, the Madhya Pradesh law and the Orissa law, were challenged. The challenge went all the way up to the Supreme Court of India, and the Supreme Court of India, in what is known as the Stanislaus case, upheld these laws on the ground that conversion could create a problem of public order. The judgment of the Supreme Court in the Stanislaus case is a problematic judgment, and many jurists have said it's been wrongly decided and that it needs to be reconsidered. But that has enabled a lot of other states to pass laws. But as I mentioned to you, the qualitative difference between those laws, the early laws and the later laws, still remains.
Right. Ma'am, so there's a question from an audience. Anushka is asking that the Supreme Court this Wednesday refused to intervene immediately and examine the constitutional validity of the laws enacted by state governments like Uttarakhand, Uttar Pradesh, which criminalize conversion through marriage and mandate prior official clearance before marrying into another faith. What would you say about it?
Yeah. I actually think it was a good thing that the Supreme Court did not intervene. The reason for that is because a much earlier petition was filed in the Allahabad High Court, first and foremost. This was an ordinance. Secondly, it was a state law, and legitimately, it ought to be challenged in the Allahabad High Court, and it was challenged in the Allahabad High Court. So I would not fault the Supreme Court for not interfering. And it doesn't amount to a refusal, because the petitions challenging the validity of the laws have been kept pending and notice has been issued. And they will be heard, because those petitions challenge not only the law of Uttar Pradesh, but also other states.
Right. Ma'am, there's one more question from Romit Sarkar. There is an aspect of determining one's religion in the new CAA Act. How can one develop reasonable and accurate guidelines for this? Do the existing anti-conversion laws shine some light on this?
The CAA law, as we all know, is a problematic law. It links to the earlier question that you raised of are we a secular country and what does this mean? So when it comes to the CAA laws, the link between citizenship and being a national of the country is not based on religion. So that's the real problem with CAA. On the question whether, it's an interesting question, on the question whether it can throw some light, I can only say that freedom of religion is a fluid concept, in the sense that one can acquire religion, one can, shed a religion at any point of time in one's journey through life. But I'm not sure whether we can say we can change our religion for the purpose of becoming a citizen. There is no jurisprudence on that subject. Moreover, when we refer to CAA, we're talking about an issue where a person is saying, this is my religion and I'm being discriminated against because I belong to this religion. So the issues there really are issues relating to discrimination, Article 14 and Article 21, And of course, the consequential questions that flow from that, namely, how does one actually prove? There are many other situations in which it's very difficult to prove that you belong to a particular religion, unless you belong to a religion in which there are certain definite rituals. Hinduism, for example, doesn't have those rituals. So I don't even know how, as an individual, as a person, would prove that I belong to the Hindu religion. These are some of the issues that will arise in the CAA challenge, as we all know. But the critical issue is going to be the issue of secularism.
Right. Ma'am, so even when we think about conversion by choice as a legal remedy, how can individuals prove their intention behind their conversion if contested? And with whom does the burden of proof lie with in this case?
Right. So I don't have to prove my intention to anybody. I don't have to prove to anybody. In fact, one can go to the extent of saying that even when you have all these official forms, etc., which ask you to disclose your religion, supposing I turn around and say, I'm sorry, my religion is something very private, I don't want to disclose it. So the question of proving intention simply doesn't arise. As I said earlier, it's a matter between you and your conscience. I don't have to prove my conscience to anybody. So the question of burden of proof doesn't arise at all. What can arise is the converse, for example, that I gave of Hindu men who convert for the purpose of taking another wife. Okay?
Right.
So there, the apparent reason for conversion is right in front of you, which is a reason which is against the law. And then, of course, when it is prima facie against the law, then the burden is on you to show, well, I didn't convert for the sake of, getting rid of my other wife. I converted because I believe in Islam. But otherwise, I don't see any reason why I should be asked to disclose my intention or proof of my intention.
Ma'am,
I can be a Hindu without ever going to a temple.
Right, exactly. Ma'am, so Himadri Chakravarti has another question. He asks, what's your take on whether and how state can be held more monetarily liable for violation of fundamental rights such as freedom of religion? For example, during the Gujarat riots, secularism was probably cited as a reason for not paying for the rebuilding of the damaged mosques by the state. 2. The census 2011 has seen a drop in percentage of Hindus. Can that be attributed to religious conversions, and can it be an alibi for the anti-conversion laws?
Let's take the first question first.
Yeah.
The judgment of the Supreme Court that articulated the proposition that money cannot be spent for the restoration of certain mosques in Gujarat after the 2002 riots has been heavily criticized as a flawed judgment. In abstract terms, you can say, yes, no person can be taxed for the purpose of a religion. That would be against secularism. But when you look at it in the context of a harm done by the state to prevent a mosque or a temple from being demolished, then to impose the liability on the state becomes more like a constitutional compensation, not necessarily for the right to religion. It can be a simple, straightforward claim in tort law of a violation of a fundamental right. And therefore, in such a situation, to impose a burden on the state would not be contrary to secularism. Secondly, there are several examples within the Constitution itself of money being outlaid from the state for the purposes of temples. That is one. I know when I was arguing the Shabrimala case, there was a provision in the Constitution which says a certain amount of money is going to be outlaid for the upkeep of that temple. So the question that he raised is not capable of a universal answer to meet different situations. And as I said, the judgment has been criticized. On the second issue of whether the fall in the percentage of Hindus in the country can be used as a reason to justify the anti-conversion laws. As I said, nothing can justify a person from stopping a person from changing religion. More specifically, right now we are discussing some of the UP law and the Madhya Pradesh law, which actually say that conversion cannot be linked with marriage. Now, we're not talking about a second marriage or a third marriage, but a marriage. And there, what you need to understand is we live in a country which has plural legal systems, which we call personal laws. So the choice is yours. You can marry under Hindu law if you want to, Muslim law if you want to, or the Special Marriages Act if you want to. That choice cannot be dictated by the state. You can ask the question, why can't two people keep their religion and marry under the Special Marriage Act? Of course they can, okay? But it's a choice which they alone can make. I don't think the state or a third person can tell them what choice they can make.
Right. Ma'am, so actually now that we're talking about Special Marriage Act, just a detour. So how is this act different from Hindu Marriage Act for Hindu couples belonging to the same caste or intercaste who want to register their marriage under Special Marriage Act?
Well, it's different in the sense that it does not require the performance of any rituals. If two Hindus get married under Hindu law, the proof of the marriage would depend upon the performance of certain rituals which are acceptable to their community. Secondly, their property would devolve under the Hindu Succession Act. If, on the other hand, they got married under the Special Marriages Act, what we call the form of marriage would change. And there would be the 30-day notice, and there would be the need for registration. Now, by an amendment to the Special Marriages Act, they did say that if two Hindus marry under the Special Marriages Act, they could keep their Hindu Succession Act as being applicable to them. But as I said, that amendment has also been criticized as being specifically favoring one religious group over other religious groups. There is no such amendment for Muslims, etc., etc. But in essence, the formation of the marriage differs whether you marry under the personal laws or whether you marry under the Special Marriages Act. And consequently, the application of personal laws differs.
Right. Ma'am, so basically now we are seeing there are multiple narratives that are floated or circulated in social media or even among the general public in their discussions. So one, the popular myth among Hindus that Muslim men are deliberately marrying Hindu women to increase Muslim population in the country only to dominate Hindus. Two, Hindus are being influenced by Christians because Indian liberal and secular state has always neglected or suppressed Hinduism but supported Christian missionaries. So how much of truth or merit is there in these arguments? Do you think, popular and majoritarian opinions like these are solely guiding the lawmakers, or on the contrary, it's the agenda of Hindu Rashtra propagating these fears or apprehensions?
Yes, I think the latter is the case. Why? Because we see this across issues. It's not something that we see only in relation to marriage, but yes, when it comes to marriage, I think it's very, very critical because it's also a way of controlling the sexuality of women. It's also a very patriarchal issue. Apart from being an issue of wanting to transition from a secular state to a state where you're slowly moving to a situation where you can say there's one religion alone. So I think it's the latter. And that dominates the kind of laws that are being passed, in particular the law in UP. I think there's no doubt about the fact that the popular narratives in social media have led to the formation of laws of this kind. that they are irrational, that they are not based on data, that they are not based, well, there were statistics about percentages of interfaith marriages in the country, and they're extremely low. They do not justify the kind of narrative that is being put out in social media. The other thing is that, there is definitely a kind of fear of Adivasis being converted. That's where sometimes people start talking about mass conversions. And this is again reflected in your laws, where in one of them you have indication that you cannot be allured by the promise of better education. Now, we all know that the Christian institutions do focus a lot on education at the school level, at the college level. And if a particular religion offers this kind of benefit to its followers, then to say that this is allurement itself is wrong. Okay. Again, I think the state cannot be allowed to decide whether I can opt for another religion, because if I feel by opting for this religion, I will be improving my life, then in my opinion, I don't think this can be declared illegal, as is thought to be done by some of these laws. It's the giveaway. That is the giveaway which you can see in these laws: marriage, better education, a different lifestyle.
Right. Ma'am, I know you're running short of time, but if you allow, I would like to end with one question.
Yeah.
Can we? Yeah. So,
What?
yeah. So basically now one clarificatory question, which is, do these conversion laws work only to prevent conversion from Hinduism to other religions, or do they work both ways? And the other part of it is, if individuals are misusing the varied nature of personal laws of different religions as claimed by certain parties, do you think there's a need for uniformity of personal laws or a uniform civil code? What's your take on this?
Of course, it's a very difficult question to answer. Traditionally, feminists have opposed a uniform civil code, but they have supported what they call an optional civil code. And I think the idea of an optional civil code is a workable idea, because it again gives you the option that whether you marry under that code or whether you marry under personal laws. That's the answer to the second part of your question. I'm sorry, could you please tell me the first part of the question again?
Do the laws of conversion work only to prevent conversion from Hinduism to other religions, or is it the other way around also?
Right. The way the laws are drafted are facially neutral, and they would cover presumably all religions. But as I said, some of them have within them these giveaways which indicate that in their application, they're likely to cover only conversion from Hinduism to other religion. That's also partly because the law assumes that anybody who is not a Christian, not a Muslim, not a Parsi is a Hindu. So all Adivasis are presumed to be Hindus, although they may have their own indigenous religion. And some of the states, I think it is Jharkhand being one of them, and Arunachal Pradesh being the other one, have attempted to define the meaning of indigenous religion without linking it to Hinduism and saying conversion to a religion other than the indigenous religion. And there are also these laws which say reconversion to the immediately preceding religion will not be considered conversion. Now that, again, is based on what we call the Ghar Wapsi concept, which is being sold to people as everyone who ever lived in this country has been a Hindu, and then some converted to some other religion. So I think that's the answer that I would attempt to give. Though I must tell you that normally when I write, and since you've read the article in the leaflet, you know that when I answer these questions, I try to answer them on a constitutional basis. I don't get into trying to answer narratives which are in social media, because I think that's the task for a sociologist, or it's a task for a different kind of academic. as far as my reading of the law goes, I try to confine my comments to how I see the law.
Right. Yeah. Thank you so much, ma'am. It's been an absolute pleasure hearing you talk about these laws. And I also thank Titir for painstakingly arranging this whole session and letting you come to talk to us. So thank you very much for joining us. And this talk will be made available public very shortly.
Thank you so much. I enjoyed the questions. They were very thought-provoking, and I hope at some point to be able to continue this conversation with you, and I would love to have your feedback on it. Thank you very much for inviting me.
I believe there's one more question here in the chat box.
Yeah, ma'am, if you have 1 minute more, we can take one more questions. Otherwise, it's...
All right. Okay, let's just go ahead. 1 minute.
Yeah. So Himadri's question is, you've been an ASG before. What do you think would solve the problem of government litigation, which constitutes nearly half of all litigation in the Indian judiciary?
Okay, nothing to do with conversion, but I'll answer it anyway. Well, when I was Additional Solicitor General, I had the late Mr. Ghulam Banbati as my Attorney General. And he told me very clearly that as Assistant Solicitor General, you have the discretion. If you think that a particular special leave petition is baseless and requires to be dismissed, you have the discretion to stand up and tell the judge that this petition deserves to be dismissed. That is what is expected of a law officer. To answer your question directly, I think what is needed is some spine and some backbone among our law officers who will have the courage to tell the government that you are wrong as far as this particular issue is concerned, who will tell them honestly that this particular law lacks constitutional validity and not just go to court and support it just because the government says it's a law. I hope I've answered your question. History will show that there are examples of that kind, not in India, but in other countries. I don't have the time to explain it to you, but in essence, that is my answer.
Thank you, ma'am. Thank you very much. That really helps.
Yeah. Thank you very much. It's been a pleasure talking with you. Thank you.
Thank you, ma'am. Bye. Have a good day.